Next is the termination on national interest. PWD Clause 52, PAM Contract Clause 35, and CIDB Clause 46. PWD empowers the government to terminate in interest of the national security or public welfare. CIDB similarly permits termination without fault, offering flexibility for strategic or administrative reasons. PAM 2006 lacks a dedicated national interest clause but does allow termination for convenience. The case that is related to this topic is BAM Harding versus Arab Malaysia 1996, and the facts are: partway through the project, the financier unilaterally terminated the facility, leading to the suspension of the entire project. BAM Harding sued the breach of contract. The defendant argued that they had a right to terminate under the loan and project agreement. So the issue here is whether the termination was valid under the contract terms, whether the contract BAM Hardings was entitled to damage of compensation, whether the unilateral termination was done in bad faith or against public interest. The decision here is the court held the termination clause must be strictly interpreted based on the contract. If the contract expressly allow for termination without default, then such termination is legally valid, even if the contractor has done nothing wrong. However, the contractor is entitled to fair compensation for work completed, reasonable costs, and other justifiable expenses. So the last topic I'll be talking about is the termination on corruption or unlawful or illegal activities. PWD Clause 53, PAM Contract Clause 25.1, CIDB Clause 44.1. PWD adopts a strict and immediate termination policy without the need for remedial notice. PAM and CIDB, while recognizing corruption as a serious breach, require the employer to follow procedural steps before termination, offering the contractor a chance to remedy the default. PWD approach is more punitive and final, whereas PAM and CIDB emphasizes fairness. The case that is related to this topic is Sin Young Contractor versus United Engineer. The facts are: Sin Young Contractor, a subcontractor, had been making a secret payment to an agent of United Engineer over a period of more than 10 years. These payments were made to secure contracts for installing fire protection system in projects undertaken by United Engineer. United Engineer discovered these payments are initiated legal action against Sin Yong and the individual involved. So, the legal issue here is whether the secret payments constituted bribery and corruption. The decision here is the court found the secret payment made by Sin Yong to United Engineers agent were indeed bribes. As a result, United Engineer was entitled to terminate the contract and recover the amount paid. The court emphasized that corruption undermines the integrity of contractor relationships and justified terminations.
For the next clauses, Clause 54, Payment upon suspension and termination on national interest in PWD203A, I found Clause 30, Certificates and Payment in PAM 2018, while in CIDB 2000, I found Clauses 42, Payment, that related to Clause 54 in PWD203A. For comparison, CIDB and PAM 2018, both contracts allow contractor to stop work if the employee doesn't make timely payment. CIDB 2000 permit reducing the pace of work, while PAM 2018 provide option to suspend work and if delays are prolonged to terminate the contract. In PWD 203A, the contract focus on situation where the government suspend or end the contract for national interest reason, ensuring that contractors are compensated for work completed and any related expenses incurred up to that point. We can relate this to a Malaysian cases, which is Sanisa Sdn Bhd versus Kerajaan Malaysia and Anno 2020. This case revolved around a dispute between the government of Malaysia as the employer and Sanisa Sdn Bhd as the contractor over contractual terms within a government construction project. The project involved a building 10-story car complex in Kuantan, Pahang, and the contract was based on the PWD 203A standard form. The contractor experienced delay beyond their control, leading to the issue for extension of time. Despite this, the contractor managed to complete the project within the extended timeline and a certificate of practical completion was issued. However, a complaint arose when the contractor claimed approximately 11.9 ringgit Malaysia 11.9 million ringgit Malaysia for loss and expenses incurred due to the delays. The government rejected this claim, arguing that the contractor had failed to comply with the prior notice requirement stipulated in the contract. The court ultimately ruled in favour of the government, emphasizing the importance of adhering to the strict terms of the contract. The High Court found that the contractor's failure to issue proper prior notice for losses and expenses claim rendered their claims invalid, even though the financial impact on the contractor was significant. For the next clause is clause 55, events and consequences of default by the government. In PAM 2018, I found clause 26, determination of unemployment by contractor, while in CIDB 2000, I found clause 45, determination by the contractor. For comparison, PWD203A lets the contractor terminate if the government defaults, while clause 26.1 of PAM 2018 allows termination for non-payment, work interference, or unjustified suspension, and clause 45 of CIDB 2000 lets the contractor terminate for non-payment or delays. We can relate this to a Malaysian case, which is Kembang Serantas Sdn Bhd versus Perbadanan Putrajaya and another appeal. In this case, Kembang Serantas Sdn Bhd, the contractor entered into a government contract for extensive work in Putrajaya. As the project progressed, the contractor encountered repeated delays in payment and period when the employer failed to provide essential site access. The contractor issued several written notice, clearly stating that the employer's conduct specifically for the non-payment and unjustified suspension of work constitute a fundamental breach of contract. These actions were analogous to the default described in PWD 203A clause 55. For the next clause is clause 56, certificate of termination cost. In PAM 2018, I found clause 34.1, payment resulting from determination, while in CIDB 2000, I found clause 44.4, certificate of termination cost. For comparison, PAM 2018 highlights payment following determination but is less specific about the issuance of certificate or exact details of termination costs. CIDB 2000 and PWD 203A are more closely aligned in specifying that a certificate is issued post-termination to the detailed termination cost, ensuring that the contractor is compensated for completed work and related termination expenses. We can relate this to a Malaysian case, which is Matang Selatan Engineers Sdn Bhd versus Kerajaan Negeri Melaka 2017. In this case, the dispute revolved around the premature termination of a road construction contract and the subsequent certificate of termination cost. Matang Selatan Engineering had entered into a contract with the government of Melaka to carry out roadworks valued approximately 12 million ringgit Malaysia. However, the project encountered delays, primarily because the client failed to hand over the site on time due to unresolved compensation issue with the landowner. In addition to this, the government did not make payment for the 11 interim certificate, which amount to 2.5 million ringgit Malaysia. This non-payment led to serious cash flow problems for the contractor. Despite this delay and financial issues being directly attributable to the client's own action, the government of Melaka proceeded to issue a notice of intention to terminate the contract. Eventually, the contract was terminated and the client carried out a valuation of the work completed. Following this, a final certificate of termination cost was issued, which is initially stated that 78,000 ringgit Malaysia was due from the contractor to the government. About a year later, the government revised this amount significantly, now claiming 239 ringgit Malaysia from the contractor, alleging losses and damages resulting from the termination.